And this is a date and time scheduled for a violation of probation sentencing on each of these files. Ms. Underwood, did you receive a copy of the probation violation report?
We did, Your Honor.
All right, and have you had an opportunity to review that with your client?
I have, Your Honor.
All right, and Mr. Likens, you've had ample time to discuss it with your attorney?
Yes, ma'am.
Are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes, Your Honor.
All right.
I would just like to go on the record stating, I was not the attorney at the time of plea. I believe the plea was taken in pro per.
Yes.
I am the attorney of record for sentencing.
Okay, and Mr. Likens, you had pled, and then I had asked you again if you wanted court-appointed counsel for sentencing, and you had wanted it, correct?
Yes, Your Honor.
Okay, and is there anything about other that you want to say about that, Ms. Underwood?
No,
or?
no,
Okay.
no.
So, Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in the
You have
pre-sentence?
a couple things, Your Honor. I believe on page number 1, under docket number 2321611, there the controlled substance is listed twice. I believe it only should be listed once, or Mr. Likens believes it only should be listed once.
So,
Let me give me a minute.
yeah, he only pled to 1 count. So that's correct. I think it's just a typo. So hold on, Miss Underwood. I did look at the judgment of sentence and it shows only 1 count.
Just getting it opened up here. Okay. So you're on page.
We're on
You're
the
talking.
first page of the probation violation recommendation report. It lists the charges he pled to on the 3 dockets. On docket number in the middle, 23-21611FH. It lists controlled substance possession 2 times. But when I look at the felony information as well as the judgment of sentence, it appears that he only pled to 1 count 2 only. 1 count.
Okay, so for whatever reason, I mean, it shows it accurate in my, but for whatever reason, it generated that twice.
Okay, that's fine. So we will make that change and strike that second one. Not a problem. Anything else, Ms. Underwood?
Yes. On page 2 of 4, midway down the page, under the sentencing guidelines, the 3rd position, the high 17, 32, 25, Mr. Likens also believes that is incorrect.
Because it's
Because my sentencing guidelines for the offense variables and my prior record variables.
okay. I'm going to pull each file and we're going to look at the sentencing guidelines. So give me just a second. So file numbers 24-21736. 23. All right, so we're going to start on file number 23-21610FH. Let me get back there. Okay, here's this. Here's that.
One reason I challenge that.
Hold on. No, just hold on. Let me get to where I'm going. You're absolutely allowed to challenge it. I just want to make sure I get to where I need. Looks like that's a bond violation. Get up to a judgment of sentence. Attorney. And you can help me out anytime there, Mr. Moore, on the guidelines on that file.
Sure. Yeah.
23.
We'll start on the one here, the 11 FH.
I'm on 10.
We have two to, well, okay.
I got 10, hold on. So on 23-21610FH, the sentencing guidelines were 0 to 17 months. But the sentencing guidelines don't indicate which docket it is, so that's why
Right.
it's kind of confusing.
That's
So
the
on the
report, so,
10
yeah.
file, it's 0 to 17. So I'm gonna put that down. And then I'm gonna go to the 1-1 file and hold on, let me get back there.
That one is 0 to 11 months.
Okay, and then on the 24-21736FH,
I have 2 to 17.
yep, it's 2 to 17. So
Mhm.
Mr. Likens, I think the guidelines are correct. I think you may be concerned about the PRVs and the ORVs, but they were apparently the same.
Yeah,
well, hold on. The reason there's probably a confusion is that lists 4 sentencing guidelines because of that error earlier. So there would only be 0 to 17, 0 to 11, and 2 to 17. That last 0 to 11 would be struck.
Okay, thank you.
Okay,
There's the 0 to 11.
Yeah.
There's only one there.
Oh.
Okay,
good.
No, there should be one for 0 to 11. There should only be 1, 2 to 17.
Well, we just looked in the file and the guidelines that were signed.
Okay, I'm wrong, I'm sorry.
No, we're 0 to 17, 0 to 11, and 2 to 17.
Okay.
Yeah, one of those 0 to 11s didn't need to be in there.
Gotcha, I'm sorry.
Okay.
I understand now, thank you.
Nope, okay. So anything else, Ms. Underwood?
Okay, under the, as far as time served, I should, for my first 2 counts, I should have the same amount of time served for, the docket numbers ending in 610 and 611. I should have the same amount of time.
I don't always give you credit for the same on each file.
Oh, okay.
Correct.
So I may have sentenced you to 215 on one file and not on the other.
The higher charge just takes over.
Well, it looks like, and Mr. Moore, I'll have you look into it, but it looks like at the initial sentencing, I did give you different jail terms on those 2 files. Maybe.
Correct.
So, yeah, I don't always give you the max on both files because I like to save jail time, so I don't have to initially send you to prison
Okay.
on a violation.
Understand your.
Thank you, Your Honor.
Anything else?
Not on these issues, Your Honor.
Okay.
I would just, I just want to bring up on the 3-6 file, there's 2 counts. So each count was scored guideline wise, and that's why we would have the additional guideline there. So.
Oh, that's right. Okay.
Yeah.
So Ms. Underwood, the reason there were 4 guidelines is on the 3-6 file, he did plead to 2 counts. So that 0 to 11 is correct. Okay. Before the court passes sentence, is there anything you'd like to say on behalf of Mr. Likens?
Your Honor, I believe Mr. Likens has a couple of issues, Your Honor. Mr. Likens has some mental health issues that he's dealing with and trying to deal with. And Mr. Likens has other issues as well. He, Your Honor, very much wants to figure out the best way to deal with those. He does not think, I believe at this point, that that is in an inpatient rehab. That is for the court to decide, of course. Mr. Likens has jobs that he needs to complete to get paid, Your Honor. He can pay his fines and costs. Mr. Likens would like to continue with mental health treatment. He would like to do both those things. I also think there may be an issue of just how much jail time Mr. Likens has left on this issue, Your Honor. And with all those being said, I will allow Mr. Likens to speak.
Mr. Likens, do you wish to continue in the recovery court program?
Your Honor, I do. There's a couple things a couple barriers with that, if I may, elaborate on that.
Of course.
I've been self-employed for the past 20 years almost, and I've done pretty good at that. I've had my highs, I've fixed out really high and lost a lot on a couple occasions. But right now, I have 3 jobs that I'm doing right now. All right, and I had some mental health issues. Like I said, I kind of shut down, and I was dealing with those. And I can get back to that in a second. But I was wrongfully targeted by the building inspector in Adrian. I talked to the city coordinator. He put a stop work order on one of my jobs, and I filed a complaint with the city coordinator. And since then, due to a conflict of interest, he was told to either step down from his position or be fired. So that put like 3 weeks, put me on the back burner for 3 weeks, put me behind with work, and that was extremely stressful. But now that the stop work order has been lifted, I can go back to work. My tools are still on the job, on 3 different jobs. That was stressful. I had a bad relationship issue. I had to separate myself from a woman that didn't have my best interest in mind, and that was really hard. And around the same time I was having mental health issues, I was urged to go to counseling and didn't see a psych, and so I did that like probably a month and a half ago, and I was prescribed some medications, and doing the drug test and everything like that. I was tested positive for benzos for a month, and so I guess that's not something they investigated or whatever, said I shouldn't be tested positive for that. So I quit taking my medication cold turkey, and just to avoid any conflict with the recovery court, and that wasn't a good idea. I have been diagnosed with severe anxiety disorder, social anxiety disorder. I missed recovery court. I know I did that because I can't be around people if I can't even talk or be humiliated. I can even up here at family, But so it was just a lot of things. I was told by Ms. Teskey said she was going to violate me for testing positive for benzos, and all I was doing was take my prescription that I was prescribed by my doctor.
But you also admitted to using cocaine and drinking again.
Yeah, this happened before that. I did self-medicate. I've tested positive for one substance, illicit substance, since I've been on drug court. That's the only time I've ever tested positive for that. I did drink alcohol. I take responsibility for all that. It's just trying to figure out, if my violations were motivated by substance abuse or mental health. I lost it, and I apologize. I got a lot at stake. I got a lot of good things going for me, and staying with my dad. My dad's he's a sober environment. It's just other variables that I allowed to get to me that I thought I was strong enough to avoid. But now I know I learned my lesson.
What phase are you in recovery court?
Phase 2.
Phase 2. Yep. All right. Anything else?
Your Honor, the last thing, I would like to stay in recovery court, but if I go back to recovery, if I go to rehab and everything like that, I'll be dumped out right before winter again. And with me being in the last year, I had troubles with that because I'm self-employed, working in houses and everything. And my work mainly comes in winter. And
pause for a minute. You call me on that light or do something. Okay, sorry about that because I don't want anybody to have a seizure. Go ahead.
But anyways, if I finish these jobs, like I said, I can pay off my court costs and fines with probation and everything like that. But I can't do that. I'm dumped off right before winter time. I don't know if you'd be willing to give me even like a deferred sentence. Just give me a chance to try to see if I can work this stuff out. But I got my psych appointments and everything like that. Not in my case. just had a lot of anxiety. But I know I served and I got 285 days credited towards the house agreement that's in play that maybe I took my plea for all my charges. And so I guess I was told that I would be given no more than a year in jail. And I have 285 days credited towards that year in jail. That's only leaves 20 days left. You do 10 months out of the year. Correct. That Your Honor would still honor the COBS agreement like this.
Well, the COBS agreement's gone.
Oh, is it? Okay.
Once you violated probation, that initial
Really?
COBS agreement and sentencing is out the door. I can send you to prison today. I can do whatever I want today. You understand that?
Yeah, okay, I didn't, but now I do.
Yeah, Mr. Likens, anything else?
Nope.
Mr. Moore, what were you going to say?
Well, a lot of this is new news to me. I do want to touch on the employment situation. We've been discussing that, and you know, he's focusing on this employment, which he's putting these customers, if there is customers, at a disadvantage because you know, he's not legitimate. We've discussed this. When I spoke with him, we discussed inpatient. He asked about inpatient because he said he hasn't been able, we haven't utilized that to him. And that's what really where he needs to go at this point. I would, to release him only because of these jobs that he's talking about, that's a bad idea. None of those are confirmed with me. And we've discussed this. He really shouldn't be self-employed at this point. He's not in the condition to be. He's not legally, his business is not legal. And so to focus and head that route, I think is the wrong thing. I think he needs to go to inpatient treatment. We discussed that. We've tried everything else up to this point, and that's the one thing that we haven't done.
Okay. So, Mr. Likens, the thing about recovery court is I care less about your job. I care less about how much money you're making. The focus is on recovery because this is just a cycle we've been going through over and over your whole life, right? You get your stuff together, you're doing good, you relapse, you use, you end up in jail. So you kind of just been a vicious cycle for the last couple of years. You know, you've done outpatient treatment, you've done inpatient treatment. This was for you a pretty big, you're only in phase 2. So this is a pretty big violation. And you're right, you're running out of jail time. And I don't want to send you to prison. I'd rather you complete the recovery court program so that you get a fresh start. But I care less about you being able to pay your fines and costs. I'm not Judge Sheridan who is like, pay your money or you're going to jail. I care less about that than I care about your safety and your recovery. Okay. So I do think you need an inpatient program. And if you can't find a job when you get out, or you don't have work, you can do volunteer work. All right. So it's a sentence of the court that your probation will be reinstated. You will continue in the recovery court. And I'm going to sentence you to 90 days in jail on file number 24-21736FH. I'll give you credit for this 14 days in jail on all files. And as soon as we get a bed, you can go to treatment. All right. But Mr. Likens, I think you're more important than your job.
Thank you.
Do you understand?
Yes, ma'am.
All right. So you do have the right to appeal this sentence, and my bailiff's going to hand down to your notice of right to appellate review. And there's one for each file. So I'm sorry. You're going to have to initial and date one for each file. And then you'll get copies. And if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days.
Thank you.
Somebody from MDOC, and I have you, but I don't you usually represent all the MDOC cases? All right, I received back a signed copy of the notice of right to appellate review. All right, I have somebody zooming in from West Huron Valley. Can I ask your name?
Shannon Foley.
Okay, thank you. All right, Ms. Foley, I'm gonna change your name. Judge Olsaver is, or John Glazier's in front of Judge Olsaver. So when he gets back, I will bring you back in, or you can hang out, but it'll be a few minutes, okay?
Okay, thank you.
Thank you. Mr. Goldstein, I have Mr. Simmons. All right, Mr. Simmons, if you would like to start your audio and your video, thank you so much. This is in the matter of the people of the state of Michigan versus Emmanuel Simmons. We have two files, 24-22051FH, 24-22052FH. I have David Goldstein appearing on behalf of Mr. Simmons. This is the date and time set for a continued show cause, I believe. So I have a show cause that states that it is alleged that Mr. Simmons tested positive for oxy, I'm assuming cotton, and cocaine on April 29th of 25, positive for cocaine on May 4 of 25, and that was sent off and confirmed positive for cocaine and noroxicodone by Millennial Health. I also have a letter dated July 9th from Darren Coast from my pretrial services. It says Mr. Simmons appears to be doing much better with his drug testing. His last 3 tests were positive for THC only. That would be June 16, June 25, and June 30th. And he does have a medical marijuana card. So, Mr. Goldstein, how do you wish to proceed today?
Well, Your Honor, given that Mr. Coast has verified that lately he's been testing negative except for the THC, I would ask that the show cause be dismissed.
All right, I'm more willing to set it over, Mr. Goldstein, along with the other dates. Would that be all right?
Yeah, that's what I was going to, that was the other thing I was going to suggest, Your Honor. That's fine.
So we are set for a final pretrial conference on this file on August 27 of 2025 at 8:30 in the morning. And we are set for jury trial for 2 days, starting September 10th of 25 at 10:30. Is there anything else you'd like to address today, Mr. Goldstein?
No, Your Honor.
Mr. Goldstein, if there is at some point a resolution in this matter that your client would like to avail himself of, just let us know and we will accommodate you at your convenience, okay?
Thank you, Your Honor.
Thank you, Mr. Goldstein.
You're done, Mr. Simmons.
All right, thank
Thank you, Mr. Simmons.
you.
All right, Kevin King. All right, so this is in the matter of the people of the state of Michigan versus Kevin Lynn King, file number 25-22153FH. I have Allison Arnold appearing on behalf of the people and Joseph Falcone appearing on behalf of the defendant. This is the date and time set for sentencing. I do have an advice of rights for the felony plea in the file, so I appreciate that. Mr. Falcone, is Eden Shikwana here?
Good morning, Judge.
There you are. All right. So, Mr. Falcone, have you received a copy of the pre-sentence report?
Yes, I did.
And you've had ample time to review that with your client?
Yes, sir.
Okay. And you received it as well,
I
Ms.
have it, Your
Arnold?
Honor.
All right. So, Mr. King, have you had an opportunity to read and review the pre-sentence report? All right, so you're kind of soft-spoken, so if you two could stand in front of the podium by the microphone, and then Mr. King, I need you to speak loudly because we have to record this for appellate purposes, okay? So you've had an opportunity to read and review the pre-sentence report,
Yes, Your Honor.
and you've had an opportunity to discuss it with your attorneys.
Yes, Your Honor.
Are you satisfied with both of your attorneys and the advice that they've given you?
Yes, Your Honor.
Mr. Falcone, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor. I think there were 2 pre-sentence reports and the last one we don't have.
Okay, all right. The one I have is signed by Mr. Moore for June 18 of 25 and sent to you on June 26. I only have one. Is that the updated one, Mr. Moore?
I'm assuming we sent out a corrected version, so I'm not sure on the date on that, but
Judge, that is the most recent, sorry.
Hey, thank you. All right, does the pre-sentence, well, I show he has no prior record, no misdemeanors, no felonies, and no misdemeanor juvenile offenses. The probation department has computed the minimum sentencing guidelines to be 12 to 20 months. Do you agree with that computation of guidelines, Ms. Arnold?
Your Honor.
And Mr. Falcone?
Yes, yeah.
Ms. Arnold, do we have anybody here who wishes to speak today?
We do, Gary King.
Okay, so I'll have you two have a seat again. And Mr. King. All right, and sir, I'm going to ask that you come up to that podium. And then I'm going to have you state your full name for the record, please.
Gary Dale King.
All right, and Mr. King, I know you're reading, but make sure when you look at anybody, it'll be me, okay?
Okay.
Okay, thank you. You may proceed.
No, I just want to go on the record as stating that even though the court documents and everything show that everything took place from 2018 through 2023, we have documentation that states that it started years prior to that, to the tune of hundreds of thousands of dollars. So this was premeditated. It was obviously a retirement quick plan of some sort. So it was over a decade of weekly thefts. Now he's assumed the role of a poor, destroyed person, but yet he's still living an unhindered lifestyle. So in other words, there's money that still exists. This has got to be the worst white-collar crime in the history of Lenawee County. I've looked a few things up, and the worst I could find is $400,000 embezzlement, and that person got 57 months in prison. To sum it up, he stole our retirement funds for his own personal wealth, put the family business in a financial crisis, and emotionally destroyed our father. He's openly admitted but guilty in court to stealing the money. So now I find it a slap in the face for him to be able to walk away in 6 short months while we have our dreams of a comfortable retirement taken away. He has ruined the family, destroyed the business, and taken away any financial support for future generations. I see the state guidelines state that for embezzlement over $100,000 could be a maximum of 20-year prison sentence. In this case, documented $1.7 million plus that he stole should somehow merit a means to reach a maximum penalty. My opinion is he should be imprisoned just as he has imprisoned us to keep working in our golden years. It will be improbable that we get our money back, but the longer prison term he gets, the less time he has to spend that money in front of us, rubbing it in our faces. Thank you, Your Honor.
Thank you, sir. Anyone else?
No, Your Honor.
Okay.
I did want to speak though.
Yep, I'm going to allow you to speak first.
Your Honor, what I wanted to say is, I just wanted to highlight and.
So can you stand at the podium?
Sure.
Just so it's picking up well.
Judge, I just wanted to highlight some of the stuff Mr. King said. One, the amount here is egregious. I'm sure it is the largest embezzlement in Lenawee County history. 2, the fact that it did happen over a number of years. And 3, that this caused heartbreak and really has impacted 3 generations of the King family in a profound way. And I could go into detail on that, but I know the court has the statements from David King, Gary King, and their daughters, Andrea Bash and Rebecca Keaton, which most eloquently express how this affected the family. And I hope Kevin King has read those statements and thought deeply about what's in those statements. My own experience in meeting with David King and Gary King, we met in my office and I thought, you know, I know that gambling addiction can do serious things to people and they can commit crimes and do whatever they can to support their addiction. But, you know, David and Gary King spoke with me and the 2 things that I took away is 1, they're not going to be able to retire anytime soon. And I know, you know, Gary King just talked about that, but that's significant when they've lost years of their life when they would be able to relax, to enjoy children, grandchildren, pursuits, that sort of thing. They're not going to be able to do that now because Kevin King robbed them of that opportunity. And the second thing they told me when we met in our conference room was that Kevin King lived a completely lavish lifestyle. They talked about a super extravagant wedding for a daughter. They talked about many trips he took and how when he traveled, it was always flying first class, a limousine picked him up at the airport. They said he couldn't go get a drink without tipping $20. So I think this goes above and beyond a gambling addiction to support the kind of lifestyle that he wouldn't have otherwise been entitled to, and in the process robbing them of a comfortable retirement. So that's just what I wanted to highlight to the board.
Thank you. Mr. Falcone, is there anything you'd like to, and you go stand with your attorney, please. Mr. Falcone, is there anything you'd like to say on behalf of your client?
Yes, Your Honor. I know that today you're going to impose sentence, and one of the purposes of imposing this sentence is punishment. But I would like to remind the court that Mr. King did lose his marriage. He's been disinherited by his father, and his brothers will receive his share. He was working as a janitor. He'll never have a good job again, and we still are not done with the IRS. He'll owe taxes on all the money, and basically he'll be his life is ruined, and he will be impoverished for the rest of his life. So I would like you to take that into consideration.
Mr. King, is there anything you'd like to say on your own behalf?
Yes, Your Honor, I'm well aware of the emotional and financial damage I've done to my entire family. I'm not sure how I'm going to carry this the rest of my life. I know I'll never be able to make it right with any of them. My hope is that maybe somehow I can make it better.
Was the 40,000 in restitution paid?
It was not, Your Honor.
Mr. King, let me go back here. Do you own a home?
I do not, Your Honor.
Okay, and you're divorced now?
Yes, Your Honor.
Was the home sold during the divorce?
It was not.
Okay, and your wife got the house?
Correct, Your Honor.
Did you get equity?
No, Your Honor.
All right, and stay there. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. It seems like the most egregious offenses that come before the court are perpetrated on people that trusted and loved them, whether it's murder, domestic violence, embezzlement. In this case, you know, it was a family company. They had immense trust in you, and you have devastated and changed all of their lives in so many ways. I don't know if it's the most money that's ever been stolen in Lenawee County, but you know, we had money stolen from band students who weren't able to go on band trips. We see this quite a bit because people trust people to be faithful and true to them. So there was an agreement at one point that if he paid 40,000, there would be a more minimal jail term, but he has not paid that.
Right, that was the topic.
Yeah, so it is a sentence of the court that you will serve 12 months in the Lenawee County Jail. You'll be placed on probation for a period of 3 years. You will have 1 day credit that you've already served. During the term of probation, you will obey and comply with all the articles of your probation. You will pay $750 in court costs, $130 crime victim rights fee, $68,000 in state costs, a $60 DNA fee. There's a $30 per month supervision fee, 60 if we have to put a tether on you. Restitution is set in the amount of $1,730,500.60. And when you get out, obviously you're gonna have to get more than one job and start paying on that. You're not to, Mr. Moore, is there an alcohol issue?
You know, I don't, not that I have, that I'm aware of, but I do know, you know, that he would drink, but you know, it's up to you, Your Honor.
Okay, so during a term of probation, you're not to violate any criminal laws. You can't leave the state of Michigan without consent of this court. You must report as required. Notify them of any change of address or employment status. You are not to participate in gambling or gaming activities or enter gambling or gaming establishments unless you first obtain written permission from the field agent. I can tell you I'll probably deny that if you ask. You must submit to search of your person and property, including but not limited to your vehicle, residence, computer, without need of warrant if the agent has reasonable cause to believe you have items which violate the conditions of your probation. You must maintain employment of up to at least 30 hours per week. Any tax refunds must be submitted to go towards the restitution and other fines and costs. Anything else, Mr. Moore?
Off. Just say he needs to report to me following business day upon his release from jail.
So when you get released from jail, the first business day you need to report to Mr. Moore. We're open 8 to 4:30, Monday through Friday. So my bailiff's going to hand down to you your notice of right to appellate review. So we're going to have you initial and date one copy just for our records. The other copies are for you. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. And then if Mr. Falcone and Ms. Arnold could approach. Right. Make sure I did that right. Okay. Yeah, okay, thank you. Okay, me too.
Was there a second attorney?
Yeah.
I'll get the name, Judge. I'll get the name later. It's okay.
Join. Highlighted in the middle.
Thank you.
All right. So Ms. Wagner, why don't you come on up? You all set? Thank you, sir.
Thank you, Judge.
You're welcome. The record should reflect I received back signed copy of the notice of right to appellate review. All right, Miss Wagner, find you. Right in here somewhere. Bradley Summerfield.
Yeah. Vice President.
Miss Adams, we do not, could I get advice of rights from Mr. Summerfield? I'm sorry.
The appeal papers.
Appeal papers, I mean. All right, there you are. All right, this is in the matter of the people of the state of Michigan versus Bradley Christopher Summerfield, file number 25-22199FH. I have Amanda Wagner appearing on behalf of Mr. Summerfield. This is the date and time set for sentencing in this matter. Mr. Summerfield, well, Ms. Wagner, you received a copy of the pre-sentence report, correct?
I did, Your
All
Honor.
right, and Mr. Summerfield, actually, can you guys stand behind the podium?
Yes.
Every court does it different, and circuit court always stands, district court sits. Okay. So, Mr. Summerfield, you did get a copy of the pre-sentence investigation report?
Yes, sir.
Okay, and you've had a chance to review that with Ms. Wagner?
Yes.
All right, are you satisfied with Ms. Wagner as your attorney and the advice that she has given you? All right, Ms. Wagner, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Your Honor, there's a couple minor things, nothing really substantial, just a couple things that I wanted to note. I'm in the process of confirming Mr. Summerfield sent in Osceola. I know you have it listed as July 22nd. I received a notice from Osceola that said August 22nd, but when we were taking the plea, I believe the court gave a July date, so I will confirm that. And then additionally, Mr. Summerfield does maintain that he did obtain his GED. He believes it was in 2015 from the LASD Tech Center. I'm going to try to confirm that as well ahead of his sentencing in Osceola, but I just wanted to note that for the court.
Okay, and all you would have to do is get a copy of that and give it to the probation officer, all right? Yes? Okay, we just have to have audible responses. Okay. Ms. Wagner, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, Your Honor.
Probation Department has computed the minimum sentencing guidelines to be 0 to 9 months. Do you agree with that computation of guidelines?
Yes, Your Honor.
Before the court passes sentence, is there anything you'd like to say on your client's behalf?
Yes, Your Honor. When I was first retained by Mr. Summerfield, given my previous limited experience with recovery court, I believed that he was going to be a good candidate for that. And so far, he's proving me right about that. I'm really happy to hear that he's doing so well. He's had no positive tests since he's been out of jail. He's been attending treatment. He's working full time. And Mr. Summerfield has a ton of incentive to successfully complete recovery court, not only because of the plea deal here in Lenawee, but the one in Osceola as well. He has no prior felony convictions. This was his first here in Lenawee and his second in Osceola, and both of those will be reduced to misdemeanors upon his successful completion of recovery court here. So I have a lot of optimism that he's going to continue doing well, and I would ask the court to follow the sentencing recommendation.
All right. So, Mr. Summerfield, is there anything you'd like to say on your own behalf? Say it louder.
No, Your Honor.
Okay. All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and the protection of society. You know, he's been attending already, you know, he has a very good outlook and just kind of a happy personality. So I feel like he's at a good place in his life and he has embraced the recovery court program and done well so far. So I have high hopes that you will successfully complete the program. So it's sent to the court, you'll be placed on probation for a period of 3 years. During that term of probation, you can't use or possess any alcoholic beverages. You're required to test as required. You can't use any controlled substances, illegal, or possess any paraphernalia. Because we are a federally funded program and marijuana is not legal with the federal government, we also cannot allow people to use marijuana as part of our program. You need to provide verification of your GED or high school diploma to Mr. Moore. You must complete any outpatient or residential treatment when referred to by the agent. Can't use any object as a weapon. They can enter your residence at any time for probation supervision. And if they have reasonable cause to believe you have items which violate the conditions of your probation, they can search your house, your car, your phone, whatever they need to. You must report any police contact, arrest, loss of employment, or change of residence. Maintain employment of up to 30. You're working, right?
Yeah.
Because your boss is, yeah, okay. There is a crime victims' rights fee in the amount of $130 supervision fee, 60 if you have to put a tether on you, $750 in court costs, $60 DNA fee, $68 state costs. What you need to understand, and you've been on probation before, is a lot of times people look at probation like, if I do something wrong, I better run and hide. And if you do that, you go to jail, right? But if you have a relapse and you go to your team and you say, I relapsed, I need help, you're gonna get help, right? If you miss a drop, we do 24 hours, but we do it at your convenience. Like, we're working hard for your sobriety. We're not trying to be punitive. So it's different than any other probation. I think you might have seen that a little bit. So just remember, honesty keeps you out of jail. Lying will put you in jail, right? Okay. So you do have the right to appeal the sentence. Mr. Moore, anything else?
No, Your Honor, just, he knows he's gonna come see me Tuesday for orientation.
So you do have a right to appeal the sentence. My bailiff's gonna hand down to you your notice of right to appellate review. You're gonna initial and date one copy for my records, the other copies are for you. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. And I received back a signed copy of the notice of right to appellate review. So I'll see you in 2 weeks. Bye, thank you. Hey, this is Judge Anzalone. I was actually looking, I don't have, never mind. I thought I had Sam Malaro, but I don't. So I'll call you back later when I get them.
All right.
Thanks, bye. John Glazier, I do have Shannon Foley. Sam must be down in front of Judge Holsaver. All right, Ms. Foley, thank you for your patience this morning. This is in the matter of the people of the state of Michigan versus Shannon Marie Foley, file number 25-22138FH. I have John Glazier appearing on behalf of Ms. Foley. Ms. Foley is joining us from the Huron Valley Detention Center. So, Mr. Glazier, you received a copy of the pre-sentence report.
Yes, Your Honor.
All right, Ms. Foley, have you had an opportunity to read and review the pre-sentence report?
Yes, ma'am.
Okay, have you had an opportunity to discuss the pre-sentence report with Mr. Glazier?
No, we have not.
Okay, Mr. Glazier, you need a breakout room?
Yeah, it'll just take a couple minutes.
Okay, and Ms. Foley, I had to put you back in the waiting room because we were getting, not from you, but background noise. That was kind of messing with our recording. That's the only reason I popped you in the waiting room, okay?
Okay, all right, thank you.
You're welcome. All right, Mr. Glazier and Ms. Foley, I will open up a breakout room for the two of you. Okay. Sarah Fonseca?
Yes.
No, you're good. I don't have Mr. Malawi yet, so I was just waiting to see. I knew you were here. What are you here for?
I'm here on the Calvary matter, Your Honor. At 9 a.m. something happens.
So we show that it was dismissed.
Ah,
So that's,
my staff just confirmed this, like yesterday, I want to say.
Miss Adams,
Yes, Judge.
we got an email saying that the Pelfrey matter was dismissed, right?
I believe I got a phone message regarding that.
Okay, well, I don't want to have ex parte communications, I suppose, with the court.
Okay, well, now you're talking, so we gotta come up here to the
Okay.
podium. And I don't have the file and I know nothing about it, so I'll just put that on the record. So can you put your name and P number on the record?
Sure, Your Honor. Brendan Dennis, P 73192 on behalf of
Okay,
State
would
Farm.
you, yeah, may I have the P number again, please?
Sure. P 73192.
This is in the matter of Adam Pelfrey versus Buffy Hunter, and who are you appearing on behalf of?
I'm appearing on behalf of State Farm.
Okay, and that's 23-237-080-NI. So we received a phone call saying the matter was dismissed.
That's interesting, Your Honor, because, well, again, I don't want to have too much ex parte communication without plaintiff's counsel present. The last time we were in front of this court, State Farm had filed a motion to enforce settlement. I don't know if the court recalls that.
No.
Okay, the court denied the motion. I have had nearly no discussions with opposing counsel since that time. So the matter involving Buffy Hunter may be dismissed. I don't have a dismissal order that's been agreed to between State Farm and plaintiff. So I just want to inform the court of that as we're here today. I don't know who called the court to advise them that this matter was dismissed.
So do you want this up for another pretrial?
Well, to give the court an idea of what we are doing from State
Do you
Farm.
want, all I'm gonna ask you is. do you want
I think the court probably needs to set it for.
Okay.
Would probably be my.
So, Ms. Adams, could I get another pretrial date on a Monday afternoon for this matter?
Okay.
In person, Judge, or by?
It'll be a Zoom one.
Okay, I just want to.
Pretrials
Sure.
are Zoom, so.
Because I'm gonna lose it by doing that. Okay, I got, I'm under here.
First available is August 4th at 4 p.m.
It's 4 p.m. That'll be Zoom, and the court, can you mail out the notice of hearing?
Yes.
Okay. Okay, all right, thank you. That's a 10-minute pretrial though. I'll give you that heads up.
Okay.
Okay, all right, thank you.
Can I speak with your clerk off the record?
No.
Okay.
So we gotta go on the next one.
Okay.
All right, Mr. Glazier, are you ready with Ms. Foley?
Yes, I am, Your Honor.
You can call her or email her later if you want. Okay, so Ms. Foley, have you now had an opportunity to read and review and discuss the pre-sentence report?
Yes, ma'am.
All right, are you satisfied with Mr. Glazier as your attorney and the advice that he's given you?
Yes, ma'am.
Mr. Glazier, do you wish to explain or challenge the accuracy or relevancy of any information in this pre-sentence report?
No, Your Honor.
Does pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, Your Honor.
The probation department has calculated the minimum sentencing guidelines to be 10 to 23 months. Do you agree with that calculation of guidelines?
Yes, I do.
All right, Mr. Glazier, before the court passes sentence, is there anything you'd like to say on behalf of your client?
Just, Your Honor, we'd ask the court to file the recommendation. If the recommendation is filed, it would comply with the plea agreement in that she would be eligible for parole just a little bit before her parole eligibility on the charge she's now serving.
All right. Ms. Foley, is there anything you'd like to say on your own behalf?
No, ma'am. No, I'm good. Thank you.
Okay, well, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for the law, and protection of society. There was a sentencing agreement that was struck that the defendant's sentence will run concurrent with and not exceed the MDOC sentence she is currently serving, which is possible because the date of these events. So it's a sentence of the court that you will serve a sentence of 1 year, 8 months to 20 years with the Michigan Department of Corrections. I will give you credit for 169 days served. There's a $130 crime victim assessment fee. There is, I don't think there's a DNA fee because she's in prison right now. So I'm going to guess they just got one from her. But if we have to, there'll be another $60 DNA fee and $68 in state costs. So Ms. Foley, we will be mailing to you a notice of your right to appellate review. They'll have you initial and date a copy for our records. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days, okay?
Yes. One more
right,
question.
good
My friend can come pick up my phone now from the sheriff's department since I'm sentenced now.
I would think so.
Remember we had the prosecuting attorney, I can't remember who he was, but he said he was gonna check into it last time for us. So she can.
Yeah,
more than likely go pick it
Mr.
up.
Glazier, can you make a call on that?
Yes, I can.
All right, excellent. So thank you, Ms. Foley. Good luck to you.
Yes, thank you very much. Have a good day.
You too. Bye.
Sorry.
Hi, this is Anna Marie Anselm again. So I am ready for Ricardo Garcia, Joseph Brown, and Alvin Graves.
Garcia, Brown, and Graves.
Yes, sir.
Okay, you got it, man.
Thank you. Bye.
Thank you, bye.
All right, Mr. Malaro. So let me mark off what we've done. So we have Ms. Fonseca. Are you ready on Ms. Fonseca?
Yeah, we're ready.
Okay. Joanne, I'm sorry on that. I don't know what it was. We have to move on.
Yeah, no, that's fine. That's
Okay. All right.
Judge, can you tell me the sentence for Miss Foley?
What?
Can you tell me what the sentence was for Miss Foley?
What you recommended.
Okay, thank you.
You're welcome. Okay. Graves, Brown, Garcia. Okay, I don't know if I'm losing my mind or not, but I might be, so hold on. It's Foley. Alvin Graves, I have Joseph Brown, Ricardo Garcia. Hold on, I have a Graves file, a Brown file, Garcia file, a Gary file, and Shannon Foley file. Miss Adams, I am so sorry. I do not have a file or PSI for Sarah Fonseca.
Okay, I'll look.
All right, thank you. Hold on 1 minute, okay?
Have one good.
I need you to read it.
So we don't hold up court proceedings.
You never hold up court proceedings. All right, this is in the matter of the people of the state of Michigan versus Sarah Fonseca, file number 24-22038FH. I have Salvatore Malaro appearing on behalf of Ms. Fonseca. This is the date and time set for sentencing in this matter. Thank you. I got it now. Sorry about that. So Ms. Fonseca, have you had a chance to read and review the pre-sentence report?
Yes.
And have you had an opportunity to discuss that with Mr. Malaro?
Yes.
All right, are you satisfied with Mr. Malaro as your attorney and the advice that he's given you?
Yes, ma'am.
Mr. Malaro, can you move that microphone up? All right, Mr. Malaro, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
And there are no guidelines because this is a misdemeanor. So, does pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Not my knowledge.
All right, is there anything you'd like to say on behalf of Ms. Fonseca before the court passes sentence?
Well, Judge, first, I believe the report recommendation is appropriate and accurate. Second, I think Ms. Fonseca at the time was sort of under the influence of a bad actor. According to the report, she's in my encouragement. I think that relationship's been severed. She would not have been in this position but for that person's behavior. I would ask the court to consider as low end of fine as possible on this matter.
Ms. Fonseca has always appeared in court, always been respectful. Because this behavior, well, what is your behavior, what happened is just contrary to what she did. Thank you.
All right, Ms. Fonseca, anything you want to say on your own behalf?
No, ma'am, thank you.
All right, so Ms. Fonseca, the recommendation was for fines and costs in this matter. So it's sent to the court that you'll pay $50 in state costs and a $75 crime victim rights fee. That'll come to a total of $125, all right? How long will you need to pay that?
Just a week, maybe.
Okay, that will be paid on the 3rd floor, right across from the elevator at the clerk's office, okay?
I did have one question. In the future, if I were to, like, does this stop me from purchasing another firearm in the future?
Will it?
It should not.
Like it doesn't, yeah.
I don't know the answer to that question, okay? So,
It may prevent you from obtaining a CPL for a period of time, but it won't.
okay, my bailiff's gonna hand down to you your notice of right to appellate review. We're gonna have you initial and date one copy for our records to acknowledge you received the paperwork. The other copies are for you, and if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right?
Thank you, Your Honor.
Mr. Tantello? I think we might have had some confusion this morning, so hold on a minute. Great, you're all set. Thank you. I received back a signed copy of the notice of right to appellate review. I have 2 jail windows, 3 jail windows, nobody in them. So, Mr. Tantello, why don't you come on up? Because I will take full responsibility for some confusion on this case. So, in the matter of Adam Pelfrey versus Buffy Hunter, 23-2378080 NI. This matter was set for 9 a.m. It's 9:17 a.m. So the other attorney representing State Farm was here earlier. Our office received a call that the case was dismissed. So we took it off our docket today. They didn't specify whether it was just Buffy Hunter or State Farm, one way or the other. Mr. What's his name again, joined State?
I'm looking from State Farm.
Yes,
Yeah.
probably Mr. Dennis.
Well, he showed up and he probably was a little perturbed because he showed up and I said, oh, it's been dismissed. So I did set this for another pretrial on August 4 at 4 p.m. Like I said, we got a call, but it didn't really clarify who was dismissed. So we had it down as all dismissed.
Yes, okay, I understand. And I apologize for my lateness.
Yep, probably call him and just explain you were a couple minutes late and you were sorry. And like I said, so I don't know who called us, so.
Oh, okay, I see. Well, that's perfectly all right. Those things happen, and it was a beautiful morning for a nice drive.
Nice drive, yep. So really good European bakery and Tecumseh you could always stop at on your way back. So, yeah, so call him. I know he was a little confused, so why don't you give him a call on your drive back? All right, thank you. All right, I have 3 jail windows. If there's anybody in the jail Zoom room, go ahead and unmute your device and start your video. You know, Mr. Miller, I have a teenage daughter, and so you have these emotes or little icons you can post. I'm always afraid to post one because it might have some weird meaning that I wasn't aware of.
I feel your pain.
You feel my pain? All right. So this is, who do I got in the jail room 3?
Mr. Parson.
All right. Becky, you are more than welcome to come get some of these files. All right, this is in the matter of the people of the state of Michigan versus Ricardo Anthony Garcia II. We have 2 files set for today. Let me get back there. Three files set for today. So file number 21-20525 is set for a violation of probation sentencing. File number 25-20575 is set for probation violation sentencing. And then file number 25-22233FH is set for sentencing on a new file. I have Salvatore Malaro appearing on behalf of Mr. Garcia. And I do have Mr. Moore here today, covering for Sarah Teskey. So, Mr. Garcia, have you had a chance to read and review the pre-sentence report?
Yes, ma'am.
Okay, so I need you to maybe scoot up a little bit, and maybe talk a little bit louder. Can you repeat your answer again?
Yes, ma'am, I have.
Perfect, thank you. And have you had an opportunity to discuss the pre-sentence report with Mr. Malaro?
Yes, I have.
Are you satisfied with Mr. Malaro as your attorney and the advice that he has given you?
Yes, ma'am.
Mr. Malaro, in both reports, do you wish to explain or challenge the accuracy or relevancy of any information?
You do not, Your Honor.
Does the pre-sentence report disclose any prior conviction in which there exists any known constitutional defect?
Not to my knowledge.
All right, the probation department on the file number 25-22233FH has computed the minimum sentence guidelines to be 2 to 17 months. Do you agree with that computational guidelines?
I do have no objection to that computation.
All right, before the court passes sentence, is there anything you'd like to say on behalf of your client?
Your Honor, Mr. Garcia has always been respectful and appropriate to me, and I believe the court during while we saw a resolution of this matter. There was sort of a little bit of a nuance to the case because Mr. Garcia is on parole, and so he's not going to get credit on the 22333 FH file.
So he's on parole probation.
Yeah.
Okay.
I did talk to Mr. Face yesterday, and he said it had to be reviewed, the parole, but he did not see an issue with him being released to inpatient recovery, which is the recommendation for the 233 FH file that he's been approved and accepted the recovery for. So that being said, Judge, the probation violations, the 12 months jail with credit for 300 days served, and then continue on probation. I'm not sure what value would be gained from that since he's going to be in recovery court on the 233 FH file. I believe it's certainly within the court's discretion to follow that recommendation. I would ask the court to consider just giving him time served on those two files. Since we're asking the court to impose the conditions as recommended on the 233 FH file. And as I explained to Mr. Garcia, the item 13 on the recommendation of conditions, that my understanding is that the court imposes 6 months, but that the court certainly permits release to an inpatient program if he is sentenced to the recovery court program. So that's our request this time, judges, that the court sentence him on 233 FH to the recovery court along with all the appropriate conditions. Just on the probation violation, since he's going to be on probation for at least 3 years, to perhaps consider time served on the probation violation, as he already has credit for 300 days. That's our request.
Mr. Moore, the probation violation doesn't say that, but any jail time on that would also be with release to inpatient if available, correct?
That would be correct. If you're gonna, I'm not sure on that probation violation, I just seen in the recommendation that you would discharge that probation case if you're discharging that probation case, but you can add that in there to release for treatment.
So are you saying you have no objection to discharging him off of probation on those 2 files?
Well, I was just looking at the recommendation and I thought that's what it,
The recommendation was for a year in jail.
probation revoked, on the file I'm looking at here, which is,
Well, it said 12 months in jail and 21-20525FH and probation revoked. But
Yep.
then on 21-20575FH continued on probation and credit for time served.
okay, that's fine. Then I didn't see that.
Okay, all right. Anything else you'd like to say?
No, Your Honor.
Mr. Garcia, so you do want to partake in the recovery court program?
Yes, absolutely.
Okay, is there anything else you want to say on your own behalf?
No, just that I'm really grateful and thankful that, you know, I have this opportunity at life again. So I will give my full potential to try to complete the drug court recovery program.
Okay. All right. Determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and protection of society. It's a sentence of the court that on file number 21-20525FH, I will give you credit for 300 days already served. Wait, so confusing. All right, I'm 25. Okay. I'll give you credit for time served on file number 21-20525FH and discharge you from probation. On file number 21-20575FC, I will. Do you want to continue on probation on both of these files or no, Mr. Moore? Yes or no? You're muted. Still muted. Can't hear you.
Sorry, I would say go ahead and discharge the 25FH and then we will continue on the 75FH, the 1 year.
All right, so on file number 21-2057FH, I will continue you on probation and give you credit for time served. Okay. And then on file number 25-22233FH, I'm going to place you on probation for a period of 3 years. During that term of probation, you will obey and comply with all the provisions in your articles of probation. There is $750 in court costs, $68 state costs. There is a $30 per month supervision fee, $60 if we have to put tether on you. Crime victim assessment fee in the amount of $130. Restitution in the amount of $450. I'm going to sentence you to 6 months in jail with no credit for time served, but I will allow you to be released to an inpatient program as soon as the bed's available, and that's usually fairly quickly. You are to enter and complete the Lenawee County Recovery Court program. During that term of probation, you cannot use or possess alcohol. You must test as required. You must not use or possess any illegal controlled substances, and as well as marijuana, because we are federally funded and the federal government still has marijuana listed as an illegal controlled substance. Use prescription drugs only as prescribed, complete all outpatient or residential substance abuse treatment. Get your GED if you don't already have it. Your field agent can enter your residence at any time for probation supervision. Submit to search of your person and property, which could include your vehicle, your residence, your computer, your phone without need of a warrant. If they have reasonable cause to believe that you have items which violate your probation. Report any police or arrest contact, loss of employment or change of residence, the next business day to the field agent. Maintain at least a minimum of 30 hours of employment. Understand that we're less concerned about your employment in the beginning of the recovery court program because we're focusing on your recovery. And then once you settle in, being employed becomes a little bit more important. Do you understand that?
Yes, ma'am, I do.
Right. The recovery court is a really good program. We have good success rates. It's a nice community, so I welcome you to that program, and I look forward to seeing you when you are able to come back. So you do have the right to appeal this sentence, and we're going to send over to you your notice of right to appellate review. They'll have your initial one copy for our records. The other copies are for you. If you wish to appeal the sentence, you would fill out the information within 42 days. So Mr. Moore, once he gets a bed for you and they send you to an inpatient program, understand you have to go, you have to stay, you can't get in trouble, you can't get kicked out because that would be a violation of probation, okay?
Yes, ma'am, I had one question.
Sure.
I know I'm on parole, so do you think my parole officer will lift my detainer so I can go to the rehab?
It sounds like your attorney spoke with them. That's not going to be an issue.
Correct.
And Mr. Moore works well with Mr. Face, so I'm sure they'll make arrangements. Mr. Moore, you want to weigh in?
Yeah, so what's going to happen now that you were sentenced is that Mr. Face will complete the violation and the PV specialist will should concur with what's going on here and move forward. And at that point, your detainer would be lifted. Meanwhile, we will send someone over there to get you set up so that we can get you into a bed. Okay.
All right. Thank you.
You're welcome.
Great. Good luck to you. We'll see you soon. Okay.
Thank you so much.
For the record, that's what Mr. Face informed me yesterday.
All right. Thank you, Mr. Garcia.
Thank you.
All right. So get rid of that gentleman now, Mr. Graves. All right. This is in the matter of the people of the state of Michigan versus Elvin D. Graves, file number 23-21428FH. Salvatore Milaro appearing on behalf of Mr. Graves. This is the date and time set for sentencing in this matter. Mr. Milaro, you received a copy of the pre-sentence report.
Yes, we did.
Mr. Graves, have you had an opportunity to read and review the pre-sentence report?
Yes, I did.
All right. Have you had an opportunity to discuss that report with your attorney?
Yes, I did.
Are you satisfied with Mr. Milaro as your attorney and the advice that he has given you?
Yes, I am.
All right, Mr. Milaro, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
I do, Your Honor. On the description of the offense narrative, page 2, the last paragraph, I believe a correction's in order. It says that Mr. Graves was in possession of 57 grams of methamphetamine.
That's a lot of methamphetamine.
Seemed to be a lot, yes. When I went and looked at the police report, it's 0.57 according to the lab.
All right, so Mr. Moore, we need to put a point in there, 0.57. I know you didn't prepare this report, but it needs to be 0.57.
Other than that, Judge, we have no other corrections or additions.
Okay. Do you wish to, doesn't the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Not to my knowledge.
Probation Department has computed the minimum sentencing guidelines to be 0 to 11 months. Do you agree with that computation of guidelines?
I have no objection to that computation.
Okay. Before the court passes sentence, is there anything you'd like to say on behalf of Mr. Graves?
Judge, I believe the recommendations accurate and appropriate. Mr. Graves struggles with addiction, probably will have to struggle with it his entire life. I think Recovery Court is going to be a good program for him to give him the tools he needs so he can effectively beat back the demons of addiction. I know that he's ready and willing and able to participate in the Recovery Court program. So we'd ask the court to file the recommendation.
All right. Mr. Graves, is there anything you'd like to say on your own behalf?
I'd just like to say that I would appreciate the chance to be able to successfully complete this program. I believe that the structure that I have to follow in this program is what I need. I have done sobriety before in my life, but without the structure, I felt that it crumbles. And I believe that with this structure, I can succeed, actually build my life like I need to.
Okay. All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication of the law and protection of society. Probably one of the bright spots of my week is the Recovery Court program, because I really enjoy the time I get to spend with the people that are participants and, you know, share with them or be a part of at least their triumphs and, you know, their successes. So it's a great program. It is the sentence of the court. You'll be placed on probation for a period of 3 years. You're ordered to enter and complete the Recovery Court program. You must not use or possess any alcoholic beverages or intoxicants. You must comply with testing, not to use any illegal controlled substances or possess paraphernalia, required to test as required. As I said, we receive federal funding and marijuana is still a scheduled illegal controlled substance under federal law. So we don't want to lose our federal funding. So marijuana is included in a controlled substance you can't use. You must complete outpatient or residential substance abuse treatment when referred. They can enter your home at any time for probation supervision. You must submit to a search of your person and property without need of a warrant if they have reasonable cause to believe you have terms which violate the conditions of your probation. You must report any arrest or police contact, loss of employment, or change of residence within 24 business hours. You must make efforts to find and maintain employment. Obviously, in phase 1, we're more concerned about stabilizing recovery than we are employment. But after that, it becomes more important. Is there a release to treatment on this, or what are we doing, Mr. Moore?
I'm unaware. I have to check with the team. I mean, typically I would believe so. If Mr. Graves, did they speak with you about inpatient treatment?
They have not yet.
Okay.
But I have done rehab and I have completed rehab.
How long ago?
So, Mr. Moore, the body of the
year.
recommendation, yeah, hold on a second. The body of the recommendation doesn't talk about Recovery Court. It's only on the next page in the recommendation. He's been in jail for like 137 days. What was your last day of use, Mr. Graves?
That would be March. No, not March. Sorry, not March. No, that is not March. February. Yeah, March 7th. And before that, if I may add, before that, I was sober almost a year before I relapsed. My dog had passed away, and sorry, it's still rough, but
I know.
I had been abusing a couple of weeks before I came to jail. I did my best to do what I could, but you know, it's hard, it really is. But I feel that if I wasn't going to get rehab, I feel like I can still do it. I've got a better system out there. I've got people that are rooting for me. I've got so much, but I'm willing to do whatever the court wants me to do.
All right, so here's what I'm going to do. I'm going to order that you serve 9 months in the Lenawee County Jail with credit for 137 days. But, Mr. Moore, I want us to circle back with the team members. If they feel he needs to go to inpatient, I would like him released immediately as soon as a bed's available. If they do not feel that he needs inpatient, I would like to suspend the balance of his sentence so that he can start recovery court. Got it?
Okay, we can do that.
So you understand, Mr. Graves, if the treatment providers believe you need rehab, I'm gonna send you rehab. If they don't believe you need it right now, I'm just gonna release you, and then you have to report right away to Mr. Moore and start the recovery court program and get in contact with the people, okay?
Okay.
There is a crime victim assessment fee in the amount of $130, $30 per month supervision fee, 60 if we have to put a tether on you, $750 in court costs, $60 DNA fee, $68 in state costs. And I think that's it. Mr. Moore will be the supervising agent for you on recovery court until Ms. Teskey gets back. So no matter what, if you go to a rehab program, you got to sign a waiver so Mr. Moore can talk to them. If you get released from the jail, you need to report to Mr. Moore right away, the next business day. And he has your number, or at least reach out to him, and he'll stay in contact with you and get in contact with the recovery court providers. Okay, anything else,
Okay.
Mr. Moore?
Sounds good. I think we're all set, Your Honor.
All right, now, Mr. Graves, you do have the right to appeal this sentence, and we're going to send over to your notice of right to appellate review. But have you initial and date one copy for our records. If you wish to appeal the sentence, you would fill out the information on the other forms and mail it to the address listed on the form within 42 days, okay?
Okay.
All right, I look forward to seeing you, Mr. Graves, and good luck to you, all right?
Alrighty, thank you.
Thank you.
I have one question. How long is it, do you think I'll have to till I hear back if I go to rehab or not?
Probably next week, because it's Friday today, so probably next week.
Okay, thank you.
All right, thank you. All right, Mr. Malaro, we are ready on Mr. Brown. So
I thought we were waiting for Mr. Jones, but there he is.
there's Mr. Jones.
Okay.
All right, Mr. Moore, I think we're all set with you, unless you want to hang out.
Yeah. Thank you. You guys have a good weekend.
You too. All right, this is in the matter of the people of the state of Michigan versus Joseph Brian Brown. We have two files, one file, 24-22087FH. Mr. Brown is represented by Salvatore Malaro. This is date and time set for sentencing in this matter. Mr. Brown, have you had an opportunity to read and review the pre-sentence report?
Yes, Your Honor.
Have you had an opportunity to discuss that report with your attorney?
Yes, Your Honor.
Are you satisfied with your attorney and the advice that they have given you?
Yes, Your Honor.
Mr. Malaro, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
You know, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Not to my knowledge.
The probation department has computed the sentencing guidelines for both count one and count two to be 24 to 40 months. Do you agree with that computation of guidelines?
No objection to it.
All right, before the court passes sentence, is there anything you'd like to say on behalf of Mr. Brown?
Judge, Mr. Brown has a minimal record. A surprise if you're taking the case and meeting with Mr. Brown and representing him on this matter. I'm just kind of surprised, but I think this is sort of this whole situation is indicative of the dangers of pornography, how it leads one down a path into darkness. I don't think it was his intent to end up with CSAM on his computer or to, view these images, but that's the problem you have when you go down this road. I know that he's remorseful over this behavior. I think that the recommendation is appropriate. We'd ask the court to follow it.
Okay. Mr. Brown, is there anything you'd like to say on your own behalf?
Other than I messed up, no. I know I understand that I did something wrong, and I'm fully aware of that. I need to take account for my actions.
Okay, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and the protection of society. It's a sentence of the court that on count 1, you will be sentenced to the Michigan Department of Corrections for a period of 3 years, 36 months to 25 years, with credit for 210 days already served. You will pay $130 crime victim rights fee, $68 state costs. You are required to remain on this Michigan sex offender registry for 25 years. On count 2, it's a sentence of the court that you will be sentenced to the Michigan Department of Corrections for a period of 3 years to 10 years, with credit for 210 days already served. There's $68 in state costs, and you're to remain active on the Michigan Sex Offender Registry for 25 years. Mr. Brown, we will send over to the jail 3 copies of your notice of right to appellate review. They're going to have you initial and date a copy for our records. They'll send that back to us just so that we have that. The other copies are for you, and if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days, okay?
Yes, Your Honor.
All right, anything else, Mr. Jones?
I think we're good, Judge. Thanks.
All right, that concludes our docket. Thank you.
Have a good weekend.
You too.